Your Honor, there was a private meeting with prosecutors and a witness. The defense was excluded.
How do you know that?
That's privileged.
Tell me your source or I'll hold you in contempt.
No, and if prosecutors threaten this witness with jail, that's coercion.
You're going to jail.
So be it.
Attorney Steele had been practicing criminal defense law in Atlanta for over 2 decades when he took on the biggest case of his career, representing Grammy-winning rapper Young Thug in a massive RICO trial. Steele was 52 years old, respected by judges and prosecutors alike, known for his aggressive but professional advocacy. On June 10, 2024, in the Fulton County courtroom, he stood up and accused Judge Earl Glanville of having a secret meeting with prosecutors and a key witness, a meeting that defense attorneys were excluded from. What happened next, Judge Glanville ordering Steele arrested and sentenced to 20 weekends in jail, would trigger a legal earthquake that exposed improper witness handling, led to the judge's removal from the case, resulted in Steele's contempt conviction being overturned by the Georgia Supreme Court, and proved that sometimes the only way to protect a defendant's constitutional rights is to risk your own freedom. Before we dive deeper into this absolutely shocking story, I need you to do something. Drop a comment right now and tell me where you're watching from. Your country, your state, wherever you are. And if you believe in holding authority figures accountable when they abuse their power, hit that subscribe button. The state of Georgia versus Jeffrey started as the most high-profile criminal trial in Georgia history. Jeffrey, known worldwide as rapper Young Thug, was arrested in May 2022 along with 27 other people in a sweeping 88-page RICO indictment. Prosecutors alleged that YSL, which stood for Young Thug's record label Young Stoner Life, was actually a violent street gang called Young Slime Life, responsible for murders, armed robberies, drug dealing, and witness intimidation over a decade. The trial began in November 2023 after jury selection that lasted 10 months, the longest in Georgia history. Young Thug had been held without bond for over 2 years. The stakes were enormous. He faced potential life in prison. Steele, a highly respected Atlanta defense attorney, was Young Thug's lead counsel. Steele practiced with his wife, Colette Resnick Steele, and had represented everyone from musicians to professional athletes to elected officials. He had a reputation for fierce advocacy combined with courtroom professionalism. Prosecutors respected him. Judges trusted him. He played by the rules, until the rules themselves became corrupt. The trial was presided over by Fulton County Superior Court Chief Judge Earl Glanville, an experienced jurist who ran a tight courtroom. By June 2024, the trial had already been marked by extraordinary drama. One defense attorney arrested on gang charges herself, another attorney handcuffed for bringing prescription medication into court, public defenders threatening to quit over insufficient pay, and a key witness who kept refusing to testify. That witness was Kenneth Copeland, known in the rap world as Lil Woody. Copeland had been offered immunity in exchange for testimony that prosecutors believed would incriminate Young Thug and other YSL defendants. But Copeland didn't want to testify. He was terrified of being labeled a snitch and facing retaliation. On Friday, June 7, 2024, Copeland was called to the witness stand. He refused to answer questions. Judge Glanville held him in contempt and ordered him jailed. Copeland spent the weekend in the notorious Fulton County Jail, the same facility where another YSL defendant had been stabbed months earlier. But what happened that weekend in the judge's chambers would change everything. On Monday, June 10, 2024, Kenneth Copeland was brought back into court in handcuffs and shackles after spending 3 days in jail. He had been given immunity, meaning his testimony couldn't be used against him in his own criminal cases. Judge Glanville told him he had to testify or face more time in contempt. Before the jury was brought in, Steele stood up. His voice was calm but firm. What he was about to say would shock everyone in the courtroom. Your Honor, I need to address something very serious. I've been informed that over the weekend, you had an ex parte meeting in your chambers with the prosecutors and Mr. Copeland. The defense was not present. We were not notified. If this is true, that's a violation of Mr. Jeffrey S. constitutional rights. The courtroom went silent. An ex parte meeting means a private conversation between a judge and one side of a case without the other side present. Such meetings are generally prohibited in criminal trials because they deny defendants their right to be present for all proceedings and to know what's being said about their case. Judge Glanville's face hardened. Mr. Steele, how did you obtain this information? That's not the issue, Your Honor. The issue is whether this meeting happened and what was discussed. I'm asking you directly, who told you about conversations in my chambers? Steele knew he was stepping into dangerous territory, but he also knew that if what he'd been told was true, prosecutors and the judge had pressured a witness outside the presence of the defense. That wasn't just improper. It was potentially illegal witness coercion. Your Honor, my source is protected. But what I was told is that in that meeting, prosecutors told Mr. Copeland that if he didn't testify, he could remain in jail not just for this trial, but potentially until all 26 defendants in this case have been tried. That could be years. If that's true, that's witness intimidation. What Judge Glanville said next would set off a constitutional crisis. Judge Glanville leaned forward, his voice taking on an edge. Mr. Steele, I'm going to ask you one more time. How did you get information about what happened in my chambers? Your Honor, I cannot reveal my source. That information is protected by attorney-client privilege and work product. But the substance of what happened in that meeting is something the defense has a constitutional right to know about. Mr. Steele, if there was nothing improper about any conversation, then there's no issue. But you coming in here making accusations about what happened in my chambers without foundation is disruptive to this court. Keith Adams, Young Thug's co-counsel, stood up. Your Honor, if there was an ex parte meeting with a witness who's under oath in this trial, we have a right to know what was said. This goes to witness coercion and our client's Sixth Amendment rights. Judge Glanville's patience was wearing thin. Mr. Steele, I'm going to give you 5 minutes. If you don't tell me who told you about supposed conversations in my chambers, I'm going to hold you in contempt of court. Steele looked at his client, Young Thug, sitting at the defense table. Jeffrey's face showed concern. Steele looked at his co-counsel, then back at the judge. Your Honor, I don't need 5 minutes. I cannot and will not reveal my source. What I'm asking is that you address whether this meeting happened and what was discussed. If prosecutors threaten this witness with extended jail time to compel testimony, that's coercive and unconstitutional. Judge Glanville stood up. His voice was cold and final. Mr. Steele, you are in contempt of this court. Bailiff, take Mr. Steele into custody. The courtroom erupted. Young Thug stood up, shocked. What? You can't arrest my lawyer. Keith Adams objected loudly. Your Honor, this is improper. Mr. Steele is representing his client. He's trying to protect constitutional rights. But the bailiff was already approaching Steele. Steele, a 52-year-old attorney with over 20 years of practice and an impeccable reputation, calmly removed his suit jacket and allowed himself to be handcuffed in front of the jury, the prosecutors, his client, and dozens of spectators. As he was being let out, Steele turned to Young Thug. Don't worry, this isn't over. But what happened next would shock even Steele himself. After Steele was taken into custody, the courtroom remained in chaos. Keith Adams moved for a mistrial. Attorneys for other defendants joined the motion. Judge Glanville denied all of them. The court has an obligation to maintain order and to protect the sanctity of proceedings. Mr. Steele's refusal to comply with a direct order from this court cannot be tolerated. Later that evening, with Steele now represented by his wife, attorney Colette Resnick Steele, Judge Glanville announced his sentence. Steele would serve 20 days in the Fulton County jail, but the sentence would be served on weekends for 10 consecutive weekends. You will report to the jail at 7 p.m. every Friday starting this Friday, June 14th, and you'll be released at 7 p.m. every Sunday. This will continue for 10 weekends, ending August 18th, 2024. Steele, through his attorney wife, may request that stunned observers. Your Honor, may Mr. Steele serve his time at Cobb County Jail instead of Fulton County? That's where Mr. Jeffrey is being held. It will allow Mr. Steele to continue working on the case with his client. Judge Glanville said he would consider it. The irony was stark. An attorney asking to be jailed in the same facility as his client, so he could keep working on the defense. Outside the courtroom, legal experts were divided. Some said Steele had crossed a line by refusing a direct court order. Others said he was a hero standing up for constitutional rights even at personal cost. Tom Church, a fellow trial attorney, came to court to support Steele. What happened there is wrong. Judges aren't supposed to have secret meetings with witnesses, and when a defense attorney calls it out, they shouldn't be arrested for it. Former Fulton County public defender Chandel Summer went further. Judge Glanville may have violated the law himself. Ex parte communications with a witness are prohibited, and then to arrest the attorney who exposed it, that's retaliation. But the question remained, had the secret meeting actually happened, and what had been discussed? Judge Glanville never denied that the meeting had taken place. In fact, during his exchange with Keith Adams, Glanville had said there was nothing improper about the ex parte conversation. So the meeting had happened. The judge admitted it. He just claimed it was proper. But was it? According to legal ethics rules and constitutional requirements, judges are generally not allowed to have private meetings with witnesses in ongoing criminal trials without both parties present. There are narrow exceptions for logistical or security matters, but those exceptions don't apply to conversations about a witness's testimony or willingness to testify. Steele's information, which he had refused to reveal the source of, was that prosecutors and Judge Glanville had told Kenneth Copeland during this meeting that if he didn't testify, he could be held in jail not just through Young Thug's trial, but potentially until all 26 YSL defendants had been tried. That could take years. If true, that would be witness coercion. Threatening a witness with prolonged imprisonment, unless they provide testimony, is exactly the kind of government pressure that the Constitution forbids. Copeland had been given immunity, meaning his testimony couldn't be used against him criminally. But immunity doesn't protect you from contempt of court. And contempt can mean jail time with no defined end date until you comply. The question was, had prosecutors and the judge used that threat to pressure Copeland into testifying? Steele believed they had, and he was willing to go to jail rather than reveal how he knew. But what Steele didn't know was that his arrest had been captured on video and was already going viral. Court cameras had captured everything. Steele calmly removed his jacket. The bailiff approached with handcuffs. Young Thug standing up in shock. Keith Adams objected. Steele being let out of the courtroom. Still composed. Still professional. But clearly being arrested for trying to defend his client. The video was posted to social media within hours. By that evening, it had millions of views. Legal commentators across the country weighed in. This is what happens when judges abuse their power, one prominent defense attorney tweeted. Steele tried to expose an improper ex parte meeting and got arrested for it. Judges have secret meetings with witnesses all the time and call it case management, wrote a law professor. But when defense attorneys find out an object, suddenly it's contempt. That's not justice. That's silencing. Others defended Judge Glanville. Steele refused a direct court order. That's textbook contempt. He could have raised the issue properly instead of grandstanding. But the overwhelming sentiment was supportive of Steele. Legal ethics experts noted that if the ex parte meeting had involved discussions about compelling Copeland's testimony, it was improper regardless of the judge's intentions, and the defense had a right to know about it. Within 48 hours, Steele's wife had filed a notice of appeal to the Georgia Court of Appeals and then to the Georgia Supreme Court. The appeal argued three main points. Judge Glanville had held an improper ex parte meeting with a witness, violating Young Thug's constitutional rights. Steele's refusal to reveal his source was protected by attorney-client privilege and work product doctrine. Judge Glanville, who was directly involved in the controversy, should not have been the one to hold Steele in contempt. Due process required a different judge to hear the contempt proceedings. That third point would prove to be the key. On June 13th, 2024, just 3 days after Steele's arrest, the Georgia Supreme Court granted him emergency bond. Steele would not have to serve his first weekend in jail while the appeal was pending. The Supreme Court's order was brief but significant. It indicated that Steele had raised serious legal questions that warranted further review before he was incarcerated. Meanwhile, back in the trial court, the defense attorneys filed motions to have Judge Glanville recused from the entire case. The argument was simple. If the judge had an ex parte meeting with a key witness and then arrested the defense attorney who exposed it, he was now personally involved in a controversy that affected the fairness of the trial. How could Judge Glanville impartially rule on motions about witness coercion when he himself was accused of participating in it? The motions were assigned to a different judge, Fulton County Superior Court Judge Rachel Krause. She would decide whether Judge Glanville should be removed from the Young Thug trial. Judge Krause held a hearing. She reviewed transcripts of the confrontation between Steele and Glanville. She reviewed the law on ex parte communications. She considered whether the public's confidence in the fairness of the trial had been compromised. On July 15, 2024, Judge Krause issued her ruling. Judge Earl Glanville was recused from the Young Thug case. In her order, Judge Krause was careful. She wrote, "I have no doubt that Judge Glanville can and would continue presiding fairly over this matter." She even defended the propriety of the ex parte meeting itself, noting that judges sometimes need to communicate with witnesses about logistical matters. But she concluded, the necessity of preserving the public's confidence in the judicial system weighs in favor of excusing Judge Glanville from this case. The case was reassigned to Judge Paige Reese Whitaker, who would now oversee what had already become the longest criminal trial in Georgia history. But Steele's contempt conviction still stood. He was still facing 20 weekends in jail. And the Georgia Supreme Court still needed to rule on his appeal. The Georgia Supreme Court took up Steele's appeal with unusual speed. Contempt cases normally take months or years to resolve. But Steele was facing imminent jail time, and the case raised significant constitutional questions about the rights of defense attorneys and the limits of judicial power. The Supreme Court focused on one key issue. Judge Glanville himself had presided over Steele's contempt hearing and imposed sentence. But Glanville was also directly involved in the controversy that led to the contempt charge. Steele had accused Glanville of having an improper ex parte meeting. Glanville had then demanded Steele reveal his source. When Steele refused, Glanville held him in contempt. The Supreme Court noted a fundamental principle of due process. A judge who is personally involved in a dispute cannot be the one to adjudicate that dispute. A different, impartial judge must hear the matter. On October 22, 2024, the Georgia Supreme Court issued its ruling. Steele's contempt conviction was reversed. The court wrote, to afford Steele due process, Judge Glanville was required to recuse himself. Steele's repeated refusal to comply with Judge Glanville's direct order was conduct directed toward the judge. Steele continued to challenge the propriety of the ex parte meeting and asserted that he could not legally comply with Judge Glanville's order to disclose his source. The exchange between Steele and Judge Glanville makes clear that Judge Glanville was involved in the controversy. For these reasons, a different judge should have presided over the contempt hearing, and the failure to do so requires reversal. The contempt conviction was vacated. Steele would serve no jail time. His law license was safe. His reputation, already strong, was now enhanced. He had stood up to a judge, been arrested, appealed, and won. But the deeper questions remained. What really happened in that ex parte meeting? And had Kenneth Copeland been coerced? Kenneth Copeland, the witness at the center of the controversy, had a complicated story. Known as Lil Woody in Atlanta's rap scene, Copeland had a criminal record with 11 prior convictions. Prosecutors believed he had critical information about YSL's alleged criminal activities, including possible knowledge of murders, drug dealing, and gang operations. In exchange for his testimony, prosecutors offered Copeland full immunity. Nothing he said on the stand could be used against him in any criminal prosecution. It was an extraordinarily broad deal, the kind prosecutors only offer when they desperately need a witness's cooperation. But Copeland didn't want to testify. He was afraid. Testifying against Young Thug and YSL in a gang trial could make him a target for retaliation. In street culture, being labeled a snitch can be a death sentence. So when he was called to the stand on June 7th, Copeland tried to invoke his Fifth Amendment right against self-incrimination. But Judge Glanville explained that because he had been given immunity, he no longer had a Fifth Amendment privilege. He had to testify or be held in contempt. Copeland continued to refuse. Judge Glanville ordered him arrested and jailed. That's when the ex parte meeting allegedly occurred. Over the weekend while Copeland was in jail, There was some communication involving Judge Glanville, prosecutors, and Copeland or his attorney about Copeland's refusal to testify. The exact content of that communication has never been fully disclosed. But according to Steele's information, prosecutors told Copeland that if he didn't testify, he could be held in contempt not just through Young Thug's trial, but potentially until all 26 YSL defendants had their cases resolved. Given that jury selection alone had taken 10 months, the prospect of being held for years was real and terrifying. On Monday, June 10th, when Copeland was brought back to court, he agreed to take the stand. But his testimony was evasive, contradictory, and often hostile. He claimed not to remember things he had previously told investigators. He disputed his own prior statements. Prosecutors were frustrated. The witness they had given immunity to, the witness they had allegedly pressured to testify, was not delivering the testimony they needed. And the entire trial was now tainted by the controversy over the ex parte meeting and Steele's arrest. With Judge Glanville recused and Steele's contempt conviction overturned, the Young Thug trial resumed under Judge Paige Reese Whitaker. She inherited a mess, a trial that had been ongoing for over a year, a key witness whose credibility was destroyed, and a defense team that had legitimate grounds to argue the entire prosecution was tainted by improper government conduct. Judge Whitaker proved to be a different kind of jurist than Judge Glanville. She was more patient with defense objections, more willing to question prosecutors' tactics, and more focused on ensuring fairness. In one hearing, Judge Whitaker grew visibly frustrated with prosecutors, accusing them of purposefully misleading the court about evidence. The comment was striking because it showed that the new judge was willing to hold prosecutors accountable in ways Judge Glanville had not. Defense attorneys filed multiple motions for mistrial based on prosecutorial misconduct and the taint from the ex parte meeting. Judge Whitaker denied those motions but warned prosecutors that their conduct was being closely scrutinized. Kenneth Copeland's testimony continued sporadically over several weeks. His credibility was thoroughly destroyed on cross-examination. Steele pointed out contradictions, prior inconsistent statements, and the fact that Copeland had been threatened with indefinite jail time if he didn't testify. Mr. Copeland, you were told by prosecutors and Judge Glanville that if you didn't testify, you could be held in jail for years, weren't you? They said I could be held until all the cases were done. And that scared you, didn't it? Yes. So you testified not because you want to tell the truth, but because you were afraid of being in jail for years? I testified because they made me. The admission was devastating to the prosecution's case. A witness who testifies under threat of prolonged imprisonment is not a credible witness. The jury heard that Copeland had been coerced, and they heard it directly from Copeland himself. But the trial was not over yet. Prosecutors had other witnesses, other evidence. And Young Thug remained in custody, facing potential life in prison. As the trial dragged on into fall 2024, the prosecution's case began to unravel. Witness after witness proved problematic. Some had credibility issues due to their own criminal histories. Others gave testimony that conflicted with prior statements or with physical evidence. The prosecution's theory was that YSL was a criminal street gang responsible for murders, shootings, drug dealing, and other violent crimes. They pointed to rap lyrics as evidence of criminal conduct, arguing that Young Thug's songs were literal confessions of gang activity. The defense countered that YSL was a legitimate record label, that rap lyrics are artistic expression protected by the First Amendment, and that prosecutors were criminalizing black art and culture. Legal experts across the country criticized the use of rap lyrics as evidence. The American Civil Liberties Union, the Recording Academy, and multiple artists' rights organizations filed amicus briefs arguing that using creative expression as evidence of criminal conduct violated the First Amendment. If we allow prosecutors to use rap lyrics as evidence of gang membership, wrote one law professor, we're saying that black artists cannot express themselves creatively without being prosecuted for it. That's not just wrong. It's unconstitutional. The prosecution also faced challenges with their RICO charges. Georgia's RICO statute requires proof of a pattern of racketeering activity, meaning prosecutors had to connect Young Thug and other defendants to specific criminal acts. But many of the alleged crimes had occurred years earlier. Witnesses had died, disappeared, or recanted. Physical evidence was limited. The case relied heavily on witness testimony, and those witnesses kept falling apart under cross-examination. By November 2024, observers were predicting that the prosecution might not secure convictions on the most serious charges. As the trial entered its second year, both sides began exploring plea negotiations. Young Thug had already been in custody for over 2.5 years. Even if acquitted, he had lost years of his life and career. Prosecutors were facing the possibility of a hung jury or outright acquittals after spending millions of dollars and countless resources on the longest trial in Georgia history. In late October 2024, Young Thug's co-defendants began taking plea deals. Some pleaded to reduce charges in exchange for time served. Others received probation. The massive RICO case was breaking apart as defendants one by one decided that fighting was too risky and too costly. Young Thug faced a difficult choice: continue fighting and risk life in prison if convicted, or accept a plea deal that would give him freedom but require him to admit guilt. Steele advised his client throughout the negotiations. Steele had fought for 2.5 years to defend Young Thug. He had been arrested and held in contempt. He had appealed all the way to the Georgia Supreme Court and won. He had exposed improper conduct by the judge and prosecutors. But ultimately, the decision was Young Thug's alone. On October 31st, 2024, Young Thug accepted a plea deal. The details were complex, but the outcome was clear. He would be released from custody with time served and probation. The most serious charges were dropped. He would not spend the rest of his life in prison. As part of the plea agreement, Young Thug did not admit to being part of a criminal gang. He maintained that YSL was a record label, but he acknowledged that some people associated with YSL had committed crimes, and he pleaded guilty to charges related to gang participation. The plea was a compromise. Young Thug got his freedom. Prosecutors got a conviction. Neither side won completely. But Steele had accomplished something remarkable. He had taken on the most powerful judicial and prosecutorial forces in Georgia, stood up for constitutional principles even at personal cost, and ultimately helped his client avoid life in prison. In the months following Young Thug's plea deal and Steele's vindication by the Georgia Supreme Court, Steele's reputation reached new heights. Legal organizations invited him to speak about judicial accountability and the duties of defense attorneys. Law schools asked him to lecture on ethics and courage in the practice of law. Steele was modest about his role. In interviews, he said, "I didn't do anything heroic. I did my job. When I learned about an ex parte meeting that violated my client's rights, I had an obligation to raise it. When the judge ordered me to reveal my source, I had an obligation to protect privileged information. I took an oath as a lawyer. Sometimes living up to that oath has consequences." But others saw his actions differently. The National Association of Criminal Defense Lawyers gave Steele an award for exceptional advocacy. The Georgia Association of Black Women Attorneys honored him for standing up to judicial misconduct. Legal ethics professors used his case as a teaching example of proper attorney conduct in the face of judicial pressure. His wife, Colette Resnick Steele, who had represented him during his contempt proceedings, spoke about watching her husband be handcuffed in court. "It was one of the hardest moments of my life. I'm his wife, his law partner, and I had to watch him be arrested for doing the right thing. But I was also incredibly proud of him. He showed what it means to be a defense attorney. You don't back down when your client's rights are at stake, even if it costs you personally." The Steele law firm gained national recognition. Clients who faced serious criminal charges sought out Steele specifically because of his willingness to fight. Other attorneys wanted to work with him, to learn from him. But Steele remained focused on his core mission: defending people accused of crimes, holding the government accountable, and ensuring that constitutional rights were more than just words on paper. Judge Earl Glanville's career took a very different trajectory. After being recused from the Young Thug case, he returned to his other judicial duties. But the controversy followed him. Legal ethics complaints were filed against Glanville with the Judicial Qualifications Commission of Georgia. The complaints alleged that he had violated judicial conduct rules by holding ex parte meetings with a witness, by failing to disclose those meetings to the defense, and by retaliating against Steele for exposing the meetings. The Judicial Qualifications Commission opened an investigation. If they found that Glanville had violated ethical rules, He could face sanctions ranging from a reprimand to removal from the bench. Glanville defended his actions. He argued that the ex parte meeting was necessary to address logistical issues about Copeland's testimony, that defense attorneys could have been included, but it was an oversight, and that holding Steele in contempt was justified because Steele refused a direct court order. But legal experts were skeptical. Judges don't accidentally exclude defense attorneys from meetings with witnesses, said one judicial ethics professor. And when a defense attorney exposes misconduct, the proper response is not to arrest them, it's to fix the misconduct. The investigation was ongoing as of late 2024, but Glanville's reputation had been severely damaged. He went from being chief judge of Fulton County Superior Court, respected and influential, to being the judge who was recused from Georgia's biggest trial for improper conduct. Some attorneys who practiced in Glanville's court said he had always been heavy-handed with defense attorneys, quick to side with prosecutors, and reluctant to hold the government accountable. The Young Thug case, they said, was just the most public example of a long-standing pattern. Others defended him, saying he was a fair judge who made a mistake in a high-pressure trial. But the damage was done. Judge Glanville would always be remembered as the judge who arrested Steele. The Steele case exposed a much larger problem in the criminal justice system: witness coercion. Prosecutors have enormous power over witnesses. They can offer immunity, which removes Fifth Amendment protections. They can threaten contempt charges, which can result in indefinite jail time. They can offer leniency in other cases. They can make witness lives better or worse. That power is supposed to be used responsibly to encourage truthful testimony while respecting witnesses' rights. But it can be abused to coerce witnesses into saying what prosecutors want them to say, regardless of truth. Kenneth Copeland's situation was a textbook example. He didn't want to testify. He was afraid of retaliation. He was offered immunity he didn't ask for. He was jailed when he refused to testify. He was allegedly told he could be held for years if he didn't comply. And then he testified. But his testimony was so obviously coerced and unreliable that it hurt the prosecution's case more than it helped. Legal reform advocates pointed to the case as proof that the system needs change. "We need clearer rules about when prosecutors can compel testimony," said one criminal justice reform organization. "We need limits on how long someone can be held in contempt. And we need independent oversight when judges and prosecutors have ex parte meetings with witnesses." Several proposed reforms emerged, requiring all meetings between judges and witnesses to be on the record with all parties present, limiting contempt jail time to a specific maximum period, requiring judicial approval before prosecutors can compel immunized witnesses to testify, creating independent review boards to investigate complaints about witness coercion. None of these reforms have been enacted by early 2025, but the conversation had begun. And it began because Steele stood up in a courtroom and said, "This is wrong." The Steele case received extensive media coverage, not just in Georgia, but nationally. Legal commentators, journalists, and social media influencers all weighed in. Some coverage focused on Young Thug himself, a Grammy-winning artist whose trial had become a spectacle. His fans organized protests outside the courthouse. Celebrities spoke out about the use of rap lyrics as evidence. The case became a cultural moment about race, art, and the criminal justice system. Other coverage focused on Steele as a legal hero. Profile pieces described his career, his reputation, his decision to risk contempt rather than compromise his ethical duties. He was compared to other famous defense attorneys who had stood up to judicial power: Clarence Darrow, Thurgood Marshall, Bryan Stevenson. Still, other coverage was critical, arguing that Steele had grandstand, that he could have raised the ex parte meeting issue through proper motion practice rather than confrontational accusations in open court, that his arrest was his own fault. But the dominant narrative was clear. A defense attorney had exposed judicial misconduct, been punished for it, and ultimately been vindicated. The system had tried to silence him and failed. The case was covered by the New York Times, the Washington Post, CNN, and legal publications like The American Lawyer and Above the Law. Law professors assigned it in their classes. Criminal defense attorneys discussed it at conferences. It became shorthand for the proposition that defense attorneys have a duty to challenge improper government conduct, even when doing so carries personal risk. and it became a rallying cry. Don't be afraid to do what Steele did. In the wake of the Steele case, Fulton County made several changes to its criminal court procedures. The changes were not dramatic reforms, but they represented recognition that something had gone wrong and needed to be fixed. First, Fulton County Superior Court issued new guidelines requiring that any ex parte communications between judges and witnesses be documented in writing and disclosed to all parties within 24 hours unless there was a specific, articulable reason for confidentiality, such as witness safety. Second, the Fulton County District Attorney's Office implemented new training for prosecutors on proper witness handling. The training emphasized that while prosecutors can offer immunity and can seek contempt citations for witnesses who refuse to testify, they cannot threaten witnesses with indefinite imprisonment or use coercive tactics to obtain testimony. Third, the Georgia State Bar enhanced its ethics training for attorneys on the duty to report judicial misconduct. Steele's case showed that attorneys who report misconduct can face retaliation, so the State Bar emphasized that the ethical rules protect attorneys who make good faith reports of judicial or prosecutorial wrongdoing. Fourth, the Georgia Supreme Court issued guidance to trial judges on contempt proceedings, emphasizing that when the contempt involves a dispute between the judge and an attorney, due process requires that a different judge hear the contempt matter. These changes were incremental, not revolutionary. They didn't solve all the problems with witness coercion or judicial accountability, but they showed that the system was capable of learning from its mistakes, or at least from its most public mistakes. Law schools across the country incorporated the Steele case into their curriculum. It appeared in criminal procedure classes, legal ethics classes, trial advocacy classes. The case raised fundamental questions about the role of defense attorneys and the limits of judicial power. Professors asked their students, "What would you do in Steele's situation? If you learned about an improper ex parte meeting, would you raise it immediately in open court, or would you file a written motion? If a judge ordered you to reveal your source, would you refuse and face contempt? Or would you comply and potentially violate your ethical duties to protect client confidences?" There were no easy answers. Some students said they would have handled it differently, been more diplomatic, tried to avoid confrontation. Others said Steele did exactly what a defense attorney should do: confront impropriety immediately, publicly, and without fear of consequences. One criminal defense professor told his class, "Steele's case teaches us that being a defense attorney is not about being popular with judges or prosecutors. It's about being willing to stand up and say, 'This is wrong,' even when everyone in power disagrees with you." Steele knew he might be held in contempt. He knew he might go to jail. He did it anyway because his client's constitutional rights mattered more than his own freedom. The case also taught lessons about the importance of appeals. Steele didn't just accept the contempt conviction. He fought it through the appellate courts, all the way to the Georgia Supreme Court. And he won. The lesson: unjust rulings can be overturned if you're willing to keep fighting. Young lawyers watched Steele's example and were inspired. They saw that it was possible to stand up to power, to challenge injustice, and to prevail. They saw that the system, for all its flaws, could still produce just outcomes when attorneys were willing to fight for them. As of early 2025, the people involved in this dramatic courtroom confrontation have moved on to different chapters of their lives. But the impact of what happened remains. Steele continues to practice criminal defense law in Atlanta. His firm is busier than ever. He takes on high-profile cases and routine cases alike, maintaining his commitment to defending anyone facing criminal charges regardless of their fame or wealth. He speaks regularly about judicial accountability and the duties of defense attorneys. He's working on a book about his experiences titled "Standing Up: A Defense Attorney's Fight for Justice." Young thug Jeffrey was released from custody after his plea deal and is rebuilding his music career. He's released new music and has spoken publicly about the trauma of being incarcerated for over 2 years. He credits Steele with saving his life, saying in interviews, "Brian went to jail for me. He stood up to the judge when nobody else would. He's more than my lawyer. He's my brother." Judge Earl Glanville remains on the bench, but no longer presides over high-profile cases. The Judicial Qualifications Commission investigation is ongoing, but has not resulted in public sanctions as of early 2025. Glanville has largely avoided public comment about the Young Thug trial. Judge Paige Reese Whitaker, who took over the trial after Glanville's recusal, earned praise for her handling of the complex case. She is now considered for elevation to higher courts. Kenneth Copeland, Lil Woody, has largely disappeared from public view. His testimony did not result in convictions, and he remains a controversial figure in Atlanta's music community. The Young Thug trial itself is considered one of the most important criminal trials in Georgia history, not because of its outcome, but because of what it exposed about judicial misconduct, prosecutorial overreach, and the courage required to challenge both. The case established important legal precedents, that judges involved in controversies cannot preside over contempt proceedings arising from those controversies, that ex parte meetings with witnesses violate due process, and that defense attorneys have not just a right, but a duty to challenge improper government conduct. Legal organizations continue to study the case. It's cited in motions and briefs around the country when defense attorneys challenge judicial misconduct or witness coercion. And Steele's example continues to inspire attorneys who face difficult ethical choices. Stand up for what's right, even when it costs you, even when you're afraid, even when the judge threatens you with jail. So here's my question. Should judges who hold improper ex parte meetings face criminal charges? Should defense attorneys who expose judicial misconduct be protected from retaliation? And should there be independent oversight boards to investigate complaints about witness coercion? Share your thoughts in the comments. This story proves that one attorney with courage can expose systemic corruption and change the course of justice. But it also shows that the price of doing the right thing can be high, and only those willing to pay it can make a difference. Thank you for watching. I'll see you in the next one.